Dear viewers, today's subject matter of discussion is the sexual harassment of women at workplace. Sexual harassment of women at workplace has become a social problem, and it is an increasing problem. It has although been there since time immemorial. With more and more women coming into the workforce, we are facing this issue. We will now look at what is not sexual harassment in order to understand the contours of sexual harassment more, so that we can differentiate behavior which may amount to sexual harassment as opposed to behavior which may not amount to sexual harassment. Firstly, sexual or romantic interaction between two consensual adults, two adults who are consensually engaging in sexual behavior or any romantic interaction, even if it is in the workplace, will not amount to sexual harassment as long as they are involved in it voluntarily, willingly, and with proper consent, and both of them are adults. Even if there is a fiduciary relationship involved, even if there is a superior subordinate relationship involved, even if there is an employer-employee relationship involved in this case, if both adults are consensually doing any activity or are engaging in sexual behaviors, verbal behavior or any other kind of behavior which may look like sexual harassment, it will not amount to sexual harassment if they are consenting to such behavior. Secondly, friendly behavior, co-workers being friendly with each other, employer being friendly with the employee, employee being friendly with the employer, or any friendly behavior of such manner which qualifies as a personal interaction or any kind of interaction, a workplace interaction between two friends, that would not qualify as sexual behavior. Even if the friendly behavior involves certain sexual elements, it may not qualify as sexual harassment unless and until the behavior itself is unwelcome in nature and affects the work performance of the harassee or the person at the receiving end. Thirdly, if an employer is asking the employee to work overtime to complete the work which is due, that will not amount to sexual harassment because there is no element of sexual behavior in it. There is no element of unwelcome. Even if this behavior can be considered as unwelcome, the employee obviously in most circumstances may not want to work overtime or may not agree to work overtime. But if the employer is asking to do overtime, it may qualify as unwelcome behavior from the employee's end, but it definitely does not qualify as sexual behavior and hence will not qualify as harassment or sexual harassment. Especially if the work is due, then it may form a contractual obligation and not exactly harassment or sexual harassment. Issuing a warning by male supervisor on arriving late frequently. This is a very common example. If an employee is arriving late on more than one occasion and if the employer or any superior of such employee issues a warning to her asking her to come on time, that does not amount to sexual harassment because there is no element of sexual behavior in it, even though again that warning may be unwelcome by the person at the receiving end or the person who is allegedly arriving late. Disturbing the surrounding by loud talk or by making comments, unless they are lewd comments, unless they are comments directed towards a person which may affect their mental health and which may be sexual in nature. Just making loud talk, being loud in the premises or causing nuisance by noise does not by itself amount to sexual harassment unless it fulfills the elements of the sexual advance in the sexual advances as well as the unwelcomeness of the behavior. Sleeping in the office premises also does not amount to sexual harassment. Taking personal calls during the course of employment or during the office hours does not amount to sexual harassment, whether the employee or the employer, whoever is taking personal calls, it does not amount to sexual harassment. Not completing tasks on time does not amount to sexual harassment. Exhibiting body language which are not socially accepted as good behavior, such as moving your feet constantly or exhibiting body language which is not accepted, talking in suppose it is a classroom, talking in class or sitting with your feet on top of a bench or putting your feet on the desk is behavior which is considered as immoral behavior or unethical behavior to exhibit in a workplace. However, only because it amounts to unethical behavior or behavior which you should not exhibit at a place like a workplace, it still does not amount to sexual harassment. Vandalizing office machinery or furniture or equipment, drawing on the furniture or equipment which is also not welcome by the organization, does not amount to sexual harassment unless there are sexual graphic elements involved in it which is causing harassment to another employee or a co-worker or a subordinate. Only then it will amount to sexual harassment. Unless that element is there, only making visual representations or vandalizing office machinery or equipment, drawing on them, drawing on walls, etc. will not amount to sexual harassment. Consuming alcohol or other prohibited goods such as narcotic drugs or psychotropic substances, etc. will not amount to sexual harassment. Now, I would like to remind and I would like to most significantly make a note here that the behavior which we looked at here in this slide does not mean that all these behavior is not prohibited behavior. They are prohibited behavior under moral codes of conduct, they are prohibited behavior under work ethics, and some of them are prohibited behavior under penal and criminal legislations. However, they are not qualifying as sexual harassment and therefore do not come under the purview of the Sexual Harassment of Women at Workplace Act. Okay. It may otherwise qualify definitely as unethical, criminal, offensive, abusive behavior by other persons individually, because again these kind of ethics, morals are subjective in nature, or the society at large. Now, coming to the harasser and the harassee, I have been using this term since the beginning of the lecture. Harasser and harassee are not limited to definitions of employer and employee. Now, this is not in the perspective of the Sexual Harassment of Women at Workplace Act, because the terms harasser and harassee have not been used in the act, but under other international legal instruments as well as laws of other countries, and in the common parlance when we use sexual harassment in order to discuss the vice of sexual harassment, we do use the term harasser, who is the perpetrator, and harassee, who can be spoken of as the aggrieved party or the victim. If criminal nature is concerned, then the person is a victim. If it is looked into in the point of view of a civil remedy, then the person is an aggrieved person. Now, harasser, harassee may be a superior subordinate. So, harasser may be the superior, harassee may be the subordinate, which is in most cases the usual case, but also it may be the other way round. Sometimes a subordinate may make sexual advances which are unwelcome towards the superior, only because the power domination is the other way around, that is the superior usually has power over the subordinate, does not always mean that the sexual harassment can take place only by the superior over the subordinate. It can also be the other way around. Similarly, sexual harassment can take place between two co-workers, even non-employees. So, non-employees, for example, any person visiting the workspace who is not an employee of the organization but may be a guest, treating them, misleading them, or treating them in any form which is given under the definition of sexual harassment will amount to sexual harassment, and that person who is exhibiting such behavior may be considered as an harasser, and the non-employee who is just a guest who has come to the organization may be considered as a harassee. Similarly, if we look beyond the Sexual Harassment of Women at Workplace Act 2013, which only offers civil remedy to the women victims or women aggrieved parties, we can, if we look at the broader angle, if we look at other international instruments and globally how sexual harassment is described, a harasser and harassee are not limited to a male and female person. So, it is not always that the males can perpetrate sexual harassment against the females. It can also be the other way around, where the females are employing or are exhibiting sexual harassment against males. Males can exhibit sexual harassment against other males. So, there is a same-sex harassment going on. Same goes with females and females. And in fact, to broaden our understanding beyond these two cisgenders of male and female, we can include any gender. So, for example, a male person exhibiting sexually harassing behavior against a person of the transgender community. That also amounts to sexual harassment, and the person who is the male is a harasser, and the person who is the transgender person at the receiving end will qualify as an aggrieved party and a harassee. Sexual Harassment of Women at Workplace Act, the definition of harassee and harasser may not be there, but we do have the definitions of employee and an employer. An employer is defined under Section 2, Clause G of the Act, whereby they have divided the employer according to 3 different workplaces. First is if it is a workplace of a government or a local body, where it is a public sector undertaking or a government undertaking which is funded by a government agency or a government corporation or a cooperative society, etc. The head of the department or head of the organization or any other officer which is specified, who is specified by the government or by the organization, will act as the employer. In a private workplace or a private organization or unit of a private sector organization, department, branch of any private sector organization which is not funded by public funds or government funds, in such a private workplace, a person who is responsible for management or supervision or control of the regular affairs of the workplace will be a person who will be treated as an employer. Now, this private workplace and the responsible person obviously is subjective and will depend on facts and circumstances in each case, and will depend on the business of the workplace, how the workplace is functioning, how it is being managed, who is managing it, and who are being managed. The persons who are being managed may be treated as the employees, and the person who are the managers, who are supervising the persons who are being managed or who are controlling the persons who are being managed, may qualify as employers. Thirdly, in a dwelling house, which we saw can qualify as a workplace under the definition of a workplace under the Sexual Harassment of Women at Workplace Act, a person who employs, that is, for example, if a person who is a resident of a house who lives with his family, the head of the family, if he employs a domestic worker for the purpose of cleaning the house, head of the family or the male member of the family or the female head of the family who has actually employed and who pays the salary of the domestic worker will be the employer, will be the person who employs. Otherwise, also a person who benefits from such employment. So, in that case where one person has employed a domestic worker for the entire household, the other members of the family are also benefiting from the services of that domestic worker. In such a case, those other members may not be paying the employee, may not be looking after the employee, that is the domestic worker, directly, but implicitly they are also deriving benefits of the services provided by the employee or services provided by the domestic worker in this case. And in such case, the person who employs the domestic worker or the employee, as well as the persons who are deriving benefit of such employment, will qualify as being an employer. Similarly, employee has been defined under Section 2, subsection F of the Sexual Harassment of Women at Workplace Act. A person who is employed at a workplace for any work on a regular, temporary, ad hoc or daily wage basis, either directly or through an agent, including a contractor, with or without the knowledge of the principal employer. So, even a person who is brought into employment on a temporary basis, on a contractual basis, on an ad hoc basis or on a daily wage basis, all of them qualify as employees. They also qualify as employees if they are employed through an agent and not directly into the agency, into the organization. Even if they are brought through an agency and the principal employer does not know that this person is employed in the work of the particular organization and their work is being provided by the agent, even in that case, that person will qualify if the person is providing any service which is fulfilling the mottos of the organization, that amounts to that person who is providing the service becomes an employee. Secondly, if the person is on remuneration or not on remuneration, or even if they are working on a voluntary basis. For example, interns, apprentices, volunteers who volunteer for NGOs, etc. They also qualify as being employees even if they do not receive any remuneration. Similarly, persons who are at the receiving, a person who provides services free of cost, and persons who voluntarily work for an organization without any remuneration, persons who provide community service, they also qualify as employees if they are working under the supervision of any organization. Okay. Whether the terms of employment are express or implied, that is immaterial to define an employee. An employee is an employee even if there are no explicit terms of service explaining or calling him or defining him as an employee. Employee includes a co-worker, a contract worker, a probationer, a trainee, an apprentice, or others who may be called by any other such name, including interns. Okay. So, any co-worker can qualify as an employee. A contract worker who is working on a contractual basis for a temporary period of time or a specific period of time qualifies as an employee. A probationer is a person who is into a service or an employment whereby his employment is going to be regularized or confirmed after a given contractual period of time. That person is also qualifies as an employee. A person who is receiving training and not receiving any remuneration in that case, who is a trainee, is also an employee. An apprentice who helps the person and in exchange learns from the professional also qualifies as an employee under the Sexual Harassment of Women at Workplace Act. Okay. Now, all these employees for the understanding in the case of the Sexual Harassment of Women at Workplace Act are of course seen in the light of being women, because we are here dealing with only women employees or women who are at the aggrieved end of the things. Now, domestic worker is also does not qualify as an employee, but domestic workers are given protection under the Sexual Harassment of Women at Workplace Act. In fact, if we look at the Vishaka judgment, the Vishaka judgment has not only expanded the definition of workplace to any place which is where the work is performed or the service is provided, but also has extended the work or the employment to any kind of employment, including social work, including volunteer work, etc. Now, the definition of a domestic worker under the labor organization states that any person, whether a man or a woman, engaged in domestic work is a domestic worker. However, this is not the case with the Sexual Harassment of Women at Workplace Act. This is because the Sexual Harassment of Women at Workplace Act only considers women to be domestic workers for the purposes of the Act. It may consider domestic worker to be a man, but that man cannot seek protection or civil remedy under the Sexual Harassment of Women at Workplace Act 2013. So, for the purposes of this Act, a domestic worker is defined as a woman who is employed to the household work in any household for remuneration, whether in cash or in kind, either directly or through an agency, on a temporary, permanent, part-time or full-time basis for remuneration, whether in cash or in kind. This definition does not include any member of family of the employer, but includes people who are hired to do domestic work for the domestic or household work for the person who was the employer of the said domestic worker. Now, it may be the case that the domestic worker is hired through an agency. For example, in large residential communities these days, the residential community acts as an agent of the houses and the house owners, and the residential community itself employs the domestic worker to come and work in the house of the house owner. In this case also, the domestic worker will qualify as an employee and will qualify as a domestic worker and can seek protection as against the house owner as well as against the members of the agency which is recruiting them. Now, an aggrieved woman for the purposes of the Sexual Harassment of Women at Workplace Act can be defined under these three subheadings. First is a working employee under section 2F, which is here what we learnt about who is an employee. All these persons will come under an aggrieved woman if any act of sexual harassment is performed against them or against their interest. Secondly, a person who is visiting a workplace, like I told you, an aggrieved woman can be a person who is merely visiting a workplace, who is not an employee. So that person comes under a non-employee. So sexual harassment can also be committed against a person who is a non-employee, who has merely come to visit a workplace or visit a place which is used as a workplace. This person can also qualify as an aggrieved woman if any act of sexual harassment is performed against that person. Thirdly, a student who is studying in an educational institution, be it a school, be it a primary education center, be it a secondary education center, or be it a higher education providing a center. In any case, a person who qualifies as a student may be treated as an aggrieved person for the purposes of the Sexual Harassment of Women at Workplace Act, where such student is such student must be a female student, and such female student is on discriminatory grounds has been sexually harassed by the members of the organization or any other colleague or co-student or any teacher, any faculty member, non-faculty staff member, as the case may be. All these three categories of people qualify as aggrieved women if any act of sexual harassment is done against them. Ending the definitions here, coming to the forms of sexual harassment, we have already looked at the forms of sexual harassment when we looked at the definition of sexual harassment under section 2 clause N of the Sexual Harassment of Women at Workplace Act. However, just to clarify it a little more, physical harassment amounts to any harassment which includes touching, which includes unwelcome hugging, unwelcome touching, unwelcome any kind of touch which is physically felt by the harassee and which is physically committed by the harasser. Verbal abuse or verbal form of sexual harassment amounts to uttering words which are sexual in nature, uttering words which are lewd in nature, which are not welcomed by the person to whom they are uttered. It may be in the form of words, words which are directly indicating any sexual favor or sexual advance, any unwelcome sexual phrase, or it may also be in the form of an innuendo where it is indirectly implicating or impliedly implicating a sexual favor or a sexual advance which is unwelcome. Third is the non-verbal or visual form, where we saw, for example, showing someone visual pornography without telling them anything, or staring at them, stalking them. All this may come under, or making any lewd gestures at them without uttering any words or without assaulting them or committing battery on them or without touching them, may amount to non-verbal or visual form of sexual harassment. If any of these forms of harassment are committed in a workplace, it will amount to sexual harassment at workplace. Now, there are two types of sexual harassment. These two types of sexual harassment, however, are not enshrined categorically under the Sexual Harassment of Women at Workplace Act, but the International Labour Organization as well as the government of India and the Supreme Court has recognized these two types of sexual harassment. First is the quid pro quo type of sexual harassment, whereby the harasser is seeking sexual favors or making sexual advances in exchanges for benefits at work. So, where the person is the harasser is asking the harassee to perform any sexual act on him, to grant any sexual favor to him, or to reciprocate any sexual advance made by him in exchange of any benefits which he may provide to the harassee. So, explicit or implicitly promising the harassee that the harasser will be giving some benefits to the harassee in case where such sexual favors or sexual advances are reciprocated, that amounts to sexual harassment of the quid pro quo kind, where the harassee will succumb into the sexual harassment vacuum in allured by the benefits. Okay, this causes automatically causes a hostile environment for the employee, but not directly. it does affect the work performance of the harassee or the employee who is at the receiving end of such favors. Second type of sexual harassment is where there are no benefits guaranteed to the harassee, but an hostile environment is created which involves uninvited and unwelcome conducts or behavior, whether they are of physical, verbal, non-verbal or visual forms, which create a work environment that makes it uncomfortable for the worker to be there. So even though it does not, the employer or the harasser or whatever the case may be, does not promise any benefits to the harassee in exchange for sexual favors, he creates an environment which the worker will not like to work in, which is hostile for the worker to perform in, which makes the worker or makes the harassee feel uncomfortable in such environment to work or perform in. That also amounts to sexual harassment by creating a hostile work environment for the employee. This can come under the case where the employer or the harasser or any other person has threatened the harassee that if you do this, I shall be making things difficult for you or something of that nature, and in that case the employee or the worker becomes uncomfortable to work in such environment, and it amounts to the hostile environment type of sexual harassment. Now with this I end the first part of the lecture, whereby we looked at the definitions under the Sexual Harassment of Women at Workplace Act, as well as the definitions which are under other types, and we dealt with the initial fundamentals of sexual harassment of women at workplace. In the next lecture, we will be looking at how to prevent sexual harassment and what are the redressal mechanisms available under the Sexual Harassment of Women at Workplace Act 2013. Thank you.